Part 8. Final Clauses. Article 33. Depositary. The Secretary-General of the United Nations is hereby designated as the depositary of this convention. Article 34. Signature, ratification, acceptance, approval and accession. 1. All states are entitled to become parties to this convention by a signature, not subject to ratification, acceptance or approval, or b. signature subject to and followed by ratification, acceptance or approval, or c. accession. 2. This convention shall be open for signature as from September 1, 1980 until and including August 31, 1981 at the headquarters of the United Nations in New York. 3. After August 31, 1981, this convention shall be open for accession by all states which are not signatory states. 4. Instruments of ratification, acceptance, approval and accession are to be deposited with the depositary. 5. Organizations for regional economic integration, constituted by sovereign states members of UNCTAD, and which have competence to negotiate, conclude and apply international agreements in specific fields covered by this convention, shall be similarly entitled to become parties to this convention in accordance with the provisions of paragraph 1 to 4 of this article, thereby assuming in relation to other parties to this convention the rights and duties under this convention in the specific fields referred to above. Article 35. Reservations. No reservation may be made to this convention. Article 36. Entry into force. 1. This convention shall enter into force 12 months after the governments of 30 states have either signed it not subject to ratification, acceptance or approval, or have deposited instruments of ratification, acceptance, approval or accession with the depositary. 2. For each state which ratifies, accepts, approves or accedes to this convention after the requirements for entry into force given in paragraph 1 of this article have been met, the convention shall enter into force 12 months after the deposit by such state of the appropriate instrument. Article 37. Date of application. Each contraction state shall apply the provisions of this convention to multimodal transport contracts concluded on or after the date of entry into force of this convention in respect of that state. Article 38. Rights and obligations under existing conventions if, according to Articles 26 or 27, Judicial or arbitral proceedings are brought in a contracting state in a case relating to international multimodal transport subject to this convention, which takes place between two states of which only one is contracting state, and in both these states are at the time of entry into force of this convention equally bound by another international convention. The court or arbitral tribunal may, in accordance with the obligations under such convention, give effect to the provisions thereof. Article 39. Revision and Amendments 1. At the request of not less than one-third of the contracting states, the Secretary-General of the United Nations shall, after the entry into force of this convention, convene a conference of the contracting states of revising or amending it. The Secretary-General of the United Nations shall circulate to all contracting states the texts of any proposals for amendments at least 3 months before the opening date of the conference. 2. Any decision by the revision conference, including amendments, shall be taken by a 2/3 majority of the states present and voting. Amendments adopted by the conference shall be communicated by the depositary to all the contracting states for acceptance and to all the states signatories of the convention for information. 3. Subject to paragraph 4 below, any amendment adopted by the conference shall enter into force only for those contracting states which have accepted it on the first day of the month following 1 year after its acceptance by 2/3 of the contracting states. For any state accepting an amendment after it has been accepted by 2/3 of the contracting states, the amendment shall enter into force on the first day of the month following 1 year after its acceptance by that state. 4. Any amendment adopted by the conference altering the amounts specified in Article 18 and paragraph 2 of Article 31 or substituting either or both the units defined in paragraphs 1 and 3 of Article 31 by other units shall enter into force on the first day of the month following 1 year after its acceptance by 2/3 of the contracting states. Contracting states which have accepted the altered amounts or the substituted units shall apply them in their relationship with all contracting states. 5. Acceptance of amendments shall be effected by the deposit of a formal instrument to that effect with the depositary. 6. Any instrument of ratification, acceptance, approval or accession deposited after the entry into force of any amendment adopted by the conference shall be deemed to apply to the convention as amended. Article 40. Denunciation 1. Each contracting state may denounce this convention at any time after the expiration of a period of 2 years from the date on which this convention has entered into force by means of a notification in writing addressed to the depositary. 2. Such denunciation shall take effect on the first day of the month following the expiration of 1 year after the notification is received by the depositary. Where a longer period is specified in the notification, the denunciation shall take effect upon the expiration of such longer period after the notification is received by the depositary. In witness whereof the undersigned, being duly authorized thereto, have affixed their signatures hereunder on the dates indicated. Done at Geneva, this 24th day of May. 1980, and one original in the Arabic, Chinese, English, French, Russian, and Spanish languages, all texts being equally authentic. Annex provisions on customs matters relating to international multimodal transport of goods article for the purposes of this convention. Customs transit procedure means the customs procedure under which goods are transported under customs control from one customs office to another. Customs office of destination means any customs office at which a customs transit operation is terminated. Import-export duties and taxes means customs duties and all other duties, taxes, fees or other charges which are collected on or in connection with the import-export of goods, but not including fees and charges which are limited in amount to the approximate cost of services rendered. Customs transit document means a form containing the record of data entries and information required for the customs transit operation. Article 1. Subject to the provisions of the law, regulations and international conventions in force in their territories, contracting states shall grant freedom of transit to goods and international multimodal transport. 2. Provided that the conditions laid down in the customs transit procedure used for the transit operation are fulfilled to the satisfaction of the customs authorities. Goods and international multimodal transport shall not, as a general rule, be subject to customs examination during the journey except to the extent deemed necessary to ensure compliance with rules and regulations which the customs are responsible for enforcing. Flowing from this, the customs authorities shall normally restrict themselves to the control of customs seals and other security measures at points of entry and exit. B. Without prejudice to the application of law and regulations concerning public or national security, public morality or public health, shall not be subject to any customs formalities or requirements additional to those of the customs transit regime used for the transit operation. Article in order to facilitate the transit of goods, each contracting state shall, if it is the country of shipment, as far as practicable, take all measures to ensure the completeness and accuracy of the information required for the subsequent transit operation. B. If it is the country of destination, take all necessary measures to ensure that goods in customs transit shall be cleared, as a rule, at the customs office of destination of the goods. Endeavor to carry out the clearance of goods at a place as near as is possible to the place of final destination of the goods, provided that national law and regulations do not require otherwise. Article 1. Provided that the conditions laid down in the customs transit procedure are fulfilled to the satisfaction of the customs authorities, the goods in international multimodal transport shall not be subject to the payment of import-export duties and taxes or deposit in lieu thereof in transit countries. 2. The provisions of the preceding paragraph shall not preclude the levy of fees and charges by virtue of national regulations on grounds of public security or public health. b. The levy of fees and charges which are limited in amount to the approximate cost of services rendered, provided they are imposed under conditions of equality. Article 1. Where a financial guarantee for the customs transit operation is required, it shall be furnished to the satisfaction of the customs authorities of the transit country concerned in conformity with its national law and regulations and international conventions. 2. With a view to facilitating customs transit, the system of customs guarantee shall be simple, efficient, moderately priced and shall cover import-export duties and taxes chargeable in countries where they are covered by guarantees, any penalties due. Article 1. Without prejudice to any other documents which may be required by virtue of an international convention or national law and regulations, customs authorities of transit countries shall accept the multimodal transport document as a descriptive part of the customs transit procedure. 2. With a view to facilitating customs transit documents shall be aligned, as far as possible, with the layout reproduced below.